Great.
All rise.
Yes, Mr. Wynne.
My lord, my lady, I appear for the appellant. Mr. Kemp and Ms. Breslin appear for the respondents.
Yes. We have a supplemental bundle of authorities.
Yes.
That is in response, is it, to
the email we received
from my lady's clerk yesterday?
Yes.
Yes. Well, thank you very much for doing that.
Thank you.
Have you, Mr. Kemp, had a chance to discuss your timetable for the day?
Yes, we have. And our estimate is that we will each take 2 hours, me first, followed by potentially up to 30 minutes at the end for my reply.
Well, that sounds...
Which would take us to about 4.
That sounds fine. We've read quite a lot in this case. We've read, I think, the key documents from the core bundle. And I may say so, extremely helpful skeleton arguments on both sides. And we've had a dip into quite a number of the authorities which you've cited.
Yes.
So I think you can assume we're up to speed with the issues.
Yes.
We look forward to hearing what you have to say now.
Yes. So the issue for the court today is whether a claim having been brought, we say successfully brought, in breach of a civil proceedings order, whether the approach of the Employment Tribunal, whether it is required to treat it as a nullity and cannot engage with such a claim, or whether there is some aspect of the claim that it can engage with, permitting it to exercise its case management powers. The decision of the Employment Tribunal and the Employment Appeals Tribunal was that in this case the claim was a nullity, and the reason why, of course, was because the appellant was subject to a civil proceedings order made in 1997. He brought this claim in April 2019 without having sought permission. The respondents raised the issue of the civil proceedings order in their ET3 in their response. The tribunal listed the matter to be determined in January 2020. In September 2019, the appellant obtained the consent which we say was required under the civil proceedings order. So at the date of the Employment Tribunal hearing in January 2020, the court had before it what I would say was the seal of approval of the High Court. The High Court had reached a decision that this was a claim that was not vexatious and was sufficiently meritorious to progress. But there was authority from the House of Lords and the High Court that such a claim could not be retrospectively permitted, and that it was always a nullity. And the appellant's position at the tribunal, the EAT and here, is that in fact that's a misunderstanding of the jurisdiction of the Employment Tribunal. It's a creature of statute and the procedural rules.
Well, in the Employment Tribunal, the parties disagreed about the meaning and effect of David Pittaway's order, but that isn't an issue that is pursued before us, is it? Or is it?
So, if this court were to conclude that it is possible retrospectively to grant leave for a claim such as this, my understanding is that the respondents would not argue paragraph 1 of the order covered this claim, and therefore consent has been obtained, and therefore the matter would progress.
Right.
There is an issue, of course. That order was not challenged by the respondents. They didn't seek to set it aside when they became aware of it. There is an argument that on the proper interpretation of Section 42 of the Senior Courts Act and the terms of the order, there's an argument that the High Court does not have the power retrospectively to give leave. So it might well be a matter on which it is useful for this court to pass comment, though it's not actually an issue within these proceedings. The reason why it might be valuable to pass comment is that, of course, under Section 42 of the Senior Courts Act, there's no right of appeal to a decision from the High Court. So there is no route, it's difficult to see any route by which an individual who was not granted retrospective leave when they thought they were entitled to it, there's no route by which they could challenge the approach in law of the High Court. So that's not an issue today. It may be useful, I say, to pass comment on the proper approach.
What do you mean comment?
Obiter observations.
Obiter observations.
Okay. Never generally welcomed.
But of course, were this court to conclude that in this case retrospective leave was permitted because the matter wasn't a nullity, it's difficult to see how that is consistent with the High Court not having the power to grant retrospective leave.
Well, of course, you're going to counsel court say we can't rely on an obiter comment by an even higher court than this one in the course of your submission. So that illustrates the dangers of obiter observations. Anyway,
yes,
let's see where we go.
Of course, the obiter positions would have a different effect. Here, I say, there's a very strong overarching principle that if access to the courts is to be denied, it can only be in the clearest words.
And of course, to be fair to you, it's a different sort of obiter observation from that of Lord Brown.
Yes.
Which you say was a passing comment. You're going to say it was a passing comment, whereas you're inviting us to give a sort of full-on obiter comment.
Yes.
Anyway, let's see where we get to.
And my lords, my lady, the structure I intend to take is the structure which I set out in my skeleton argument.
This is your second skeleton.
Yes,
but,
by appellant's replacement.
At 11, is it? Tab 11.
Dated 22nd November 2022. It starts at page 136 of the whole bundle. So the structure I set out there is first I deal with the jurisdiction of the employment tribunals and their procedural rules. Then I look at the structure of Section 42 and a civil proceedings order. And I do that from which to then look at comparable restrictions, I say comparable restrictions, on individuals bringing claims. So that's the approach taken in other jurisdictions other than the employment tribunal, to civil proceedings orders, also civil restraint orders, and how in practice it seems as if, certainly on occasion, these orders and permission are dealt with. I also then look at the decision in Edwards and in Seal, having laid the background, as it were, and seek to explain why those decisions were wrongly decided. And I then point out, I seek to argue why, according to general principles, so the overriding objective, common law principles following, for example, Picks, why the effect of an order under Section 42, why it should be given the meaning which I contend for. So if I could take the court to the larger authorities bundle, please, and take the court to some of the statutory provisions. Looking first at those sections in the Employment Tribunals Act of 1996, which are behind the So the sections I rely upon are all sidelined. Section 1 provides the Secretary of State may by regulations make provision for the establishment of tribunals to be known as employment tribunals. By Section 2, Employment tribunals shall exercise the jurisdiction conferred on them by or by virtue of this Act or any other Act, whether passed before or after this Act. Further detail is provided as to what may be present in procedure regulations. That is at section 7.
So I'm just pausing at section 2. Presumably that also means that if another Act deprives the Employment Tribunal of jurisdiction, it shan't have jurisdiction and shan't exercise it.
If that was a proper interpretation of that other Act, yes. Subsection 7.1, the Secretary of State may by regulations, he quotes the Employment Tribunal Procedure Regulations, make such provision as appears to him to be necessary or expedient with respect to proceedings before employment tribunals. Subsection 2, proceedings before employment tribunals, and I say this is key, shall be instituted in accordance with Employment Tribunal Procedure Regulations. Why this subsection in this Act is important, I think, is because this claim was brought in accordance with the Employment Tribunal Procedure Regulations, and therefore I say this Employment Tribunal was obliged to progress it in accordance with its
Instituted. Yes.
But you
Is that
you
right?
accept.
Hold on. Sorry. If I fill in all the forms correctly in the Employment Tribunal, but I'm bringing a personal injury claim that's completely unrelated to employment and over which the Employment Tribunal has no jurisdiction, does that mean that the proceedings are effective?
They are effective to the point at which, within the tribunal procedure rules, a judge identifying this issue with the proceedings, the judge dismisses those proceedings.
But that would be a question of jurisdiction. I'm positing that I've brought a claim for whatever it may be, trademark infringement or something that's over which the Employment Tribunal has no jurisdiction. But the usual position, I think, is that if a court has no jurisdiction over something, it is effectively a nullity.
I would say that if it has no jurisdiction, it has no jurisdiction to determine the issues. But it does have sufficient jurisdiction to then strike out the claim. I say that the court has to do something with the claim that has been presented in accordance with its tribunal rules. It's not until the court has reached a decision as to whether there's jurisdiction that it's possible to identify definitively that the claim does not fall within the jurisdiction of the Employment Tribunal.
So it wouldn't be open to an Employment Tribunal to write to a litigant who misunderstood the whole nature of the Employment Tribunal and simply write to them saying, you seem to have misunderstood. We deal with employment matters. If you want to bring a passing off claim, you'll have to bring it in the High Court.
There is provision for an Employment Tribunal to do essentially that. But that is an exercise undertaken by a judge, having been seized of the claim in compliance with Regulation 8.
So that's a judicial function. It wouldn't be open for someone in an administrative function to do that and say, you've made a mistake and we're simply not going to engage with this further.
That is my understanding. And if I could take the court to the procedural rules.
Yes, do.
So the Employment Tribunal's Constitutional Rules of Procedure Regulations 2013 are behind tab 10. If I could take the court through those regulations from the start, and then, my Lord, address the question which you were asking me at the appropriate point. So, Paragraph 2 provides the overriding objective. I say that's relevant here. Specific provisions are within paragraph C, avoiding unnecessary formality and seeking flexibility in proceedings. E, saving expense. The paragraph continues, a tribunal shall seek to give effect to the overriding objective in interpreting or exercising any power given to it by these rules. Moving on, paragraph 6 deals with irregularities and non-compliance. Failure to comply with any provision of these rules, except Rule 8.1, etc., or any order of the tribunal, except an order under Rules 38 or 39. They are orders for striking out. Does not of itself render void the proceedings or any step taken in the proceedings. In the case of such non-compliance, the tribunal may take such action as it considers just, etc. And later we see one of the routes is striking out the claim or the response in whole or in part, in accordance with Rule 37. Paragraph 8 and 8.1, presenting the claim. A claim shall be started by presenting a completed claim form using a prescribed form in accordance with any practice direction made under Regulation 11. Now, there are routes to reject a claim form if, I say, on its face, there are certain irregularities. Under paragraph 10, the tribunal shall reject a claim if, for example, it's not made on the prescribed form or if it doesn't contain required information.
And that isn't an administrative function? It's not done administratively by staff at the tribunal?
That is an administrative function.
It is.
We see that from subparagraph 2. The form shall be returned to the claimant with a notice of rejection explaining why it has been rejected. The notice shall contain the information about how to apply for reconsideration of the rejection.
And the reconsideration is by a judge?
Yes. There is rejection in different circumstances where there are substantive defects under paragraph 12. Which is
that provides clearly that staff will refer it to a judge, doesn't
yes.
it? Yeah.
And under paragraph 12.1, the staff of the tribunal office shall refer a claim form to an employment judge if they consider that the claim or part of it may be one which the tribunal has no jurisdiction to consider in a form which cannot sensibly be responded to or is otherwise an abuse of process. Subparagraph 2, the claim or part of it shall be rejected if the judge considers that the claim or part of it is of a kind described in some subparagraphs A, B, C or D, paragraph 1. So, my Lord, this paragraph 12 is the route by which the Employment Tribunal, in receipt of a claim for an entirely personal injury claim unrelated to any of its jurisdictions, would reject that claim.
And until that happened, what was the status? What will be the status of the proceeding?
They are liable to be rejected.
But they're still valid proceedings, so that if after the time limit had expired, but before this step had been taken, they were amended to include a claim over which there was jurisdiction, then the time bar would have been effectively avoided.
I think I'm in error in that submission, if I could correct myself. I think if the claim has progressed no further than a rejection, and it has been rejected, it is then open to the claimant to seek a reconsideration under paragraph 13. claimant whose claim has been rejected in whole or in part under Rule 10 or 12 may apply for a reconsideration on the basis that either the decision to reject was wrong or the notified defect can be rectified. And then going to subparagraph 4, if the judge decides that the original rejection was correct but that the defect has been rectified, the claim shall be treated as presented on the date that the defect was rectified. So there's two potential statuses to that claim having been rejected. It may turn out that it was validly presented, validly instituted, if in fact the reasoning was wrong for the rejection. But if the reasoning was correct, if it was entirely one over which there was no jurisdiction, etc., then, but that error had been corrected, and for example, a personal injury claim identified that the personal injury was as a result of discrimination, which would be something over which the tribunal had jurisdiction. If the claim had been altered to include that, under subparagraph 13.4, the claim would then be treated as presented on the date the defect was rectified. So that would be a new claim. It wouldn't be the original rejected claim. The key point here, I say, is that at these substantive stages, there is a decision by a judge.
Okay, so it is a live claim or valid claim until such time as it's rejected.
Yes.
And even when it's rejected, it is capable of being revived.
Yes.
In the way described in 13.4.
Yes.
Or in 13.
Yes. But I say that these provisions, 12 and 13, don't apply in this situation because it is unlikely that it is clear on the face of the claim form that it is one where the individual is subject to a civil proceedings order. So if within the claim form the claimant had said, I am subject to a civil proceedings order, it applies to this, I haven't made an application and I'm not going to, in those narrow circumstances, the staff and the judge may well be able to go through the process of rejecting that.
Or if you've got a very efficient tribunal centre that has a list, as many do, of extant CPOs and the claimants who are subject to them, and a very vigilant member of staff notices and sees that there's no reference to leave, there'd be no reason not to apply the Rule 12 procedure, would there?
I say that in those circumstances, in fact, the matter moves to paragraph 26. The reason why is it won't be evident purely from the information on the claim form that this is a claim that has
Why
no
is the
reason.
power under 12.1 restricted to cases where the information which causes concern to the member of staff is on the claim form?
Because there is no route by which further information to confirm that status can be obtained.
Well, why is that relevant?
Because
The rule says if they consider that the claim may be one which the tribunal has no jurisdiction to consider. Why is that? Why are they only entitled to consider information on the claim form? Why can't they consider, as my lady suggests, a list? They have a list of people against whom CPOs have been made and the claimant's name is on that list. Why can't that be considered?
it could be considered, but I say it would be insufficient because it may be that the name of this individual is the same name as is recorded on that official list.
But it,
It may be.
it may be that it may or may not be on your. It
Yes.
may or may not be the individual.
It may or not be, but the tribunal.
But let's say it says Reverend Paul Williamson on the claim form, and the CPO says it's a CPO made in 1997 against Reverend Paul Williamson. Why isn't that a 12(1)A situation?
Because at that point the tribunal won't be aware whether or not permission has been obtained for this claim.
But it may be, where does may be? So that what the member staff does is refers it to the judge, doesn't he or she?
Or possibly writes to the Reverend Paul Williamson, says, have you obtained leave? And gets an answer no. I thought your argument was going to be, because it seems logically to fit with the rest of your argument, that this wouldn't come within 12.1a because the tribunal does have jurisdiction to consider it, and indeed is bound to exercise the jurisdiction to consider it by then going on to exercise its case management or dismissal
Yes.
or strikeout powers, so that you're not within 12.1a at all. If the proceedings are not a nullity, then I thought your argument would be, well, the only remedy is for the tribunal to exercise jurisdiction over them, but to exercise it in the sense of applying its case management or strikeout powers or not, as the case may be.
Yes, that is my argument, because I say that any more onerous interpretation of an order under Section 42 unnecessarily and disproportionately restricts an individual's access to the courts, particularly within employment tribunal proceedings, where you have very short limitation periods, including under Section 128 of the Employment Rights Act 1996. There's a 7-day limitation period with no scope for extension. So, if an individual was seeking interim relief under Section 128, the chances are is that they would have to submit an ET1, present an ET1, without having obtained permission from the High Court.
Why do you say that? You can get permission from the High Court overnight if it's urgent enough.
So,
you're positing that there is some reason for urgent interim relief, which needs to be made, and as you say, 7 days is the time limit. But it may be that 7 days would be too slow in some cases, depending on what the circumstances are. The High Court is very familiar with making the need in some cases to grant injunctions or interim orders very urgently, and it makes itself available overnight in appropriate cases. If a litigant was in a position to say this is something that needs to be done within 7 days, I don't myself readily accept that the High Court would not make itself available to grant leave for it to be done, if it were appropriate to grant.
So the circumstances of somebody making an interim relief application might well be that they were informed at short notice that they were being dismissed. So the 7 days runs from the moment they have been dismissed. Frequently in employment tribunal proceedings, individuals represent themselves, but particularly perhaps where an individual has been judged to be a vexatious litigant. There will be many circumstances in which an individual representing themselves would not manage to obtain a High Court permission within those 7 days.
Because he was unaware of the 7-day limit, or because he didn't know he was subject to the requirement to get leave in the first place?
Because it would take some time for them to establish what the rights are and prepare the documentation and find out how to make a short notice.
Well, that's a function of the 7-day cut-off, not a function of having to get leave.
Yes, so going back to first principles, the purpose of an order under Section 42 is to protect the court and potential defendants from vexatious claims. And to do so, the mechanism which is deployed is an individual subject to a CPO has to obtain the permission of the High Court to bring a claim. What an order under Section 42 does not seek to do is prevent a claim that's not vexatious or has sufficient merits from being brought and progressed. But there is this mechanism that has to be gone through. I say that the effect of that mechanism has to be applied. The order and the section has to be interpreted in such a way as to minimise any additional difficulties that might be imposed on a potential claimant. So, where a limitation period is 6 years, the individual is aware, let's say, a month after the cause of action arises, there is unlikely to be much of an impediment caused by an order under Section 42. Not much of an additional impediment if they have to seek leave. However, for a claim to be brought under Section 128 of the Employment Rights Act, I say that to have to bring at short notice an application in the High Court and get tribunal proceedings in afterwards could well pose a significant hurdle and could well prevent an individual from having their claim heard by the tribunal. And I say there's a solution. That is an unnecessary consequence, an unnecessary interpretation of those provisions, because the tribunal can, once alerted to the CPO and the fact that no permission has yet been obtained, the tribunal can, I say, stay the matter for a short period of time until permission is obtained. And if permission isn't obtained, the claim can be struck out. And I say that this works because, as we saw in this matter, to determine that the claim was a nullity, the tribunal listed a hearing at which that status was determined.
But the respondent had to invite the tribunal to do it, so the respondent had to be vigilant and aware and act. And the whole purpose of a CPO is to protect respondents from being troubled by proceedings of this kind, subject to the leave requirement.
Yes, I accept that the claim should not have been brought, but a claim having been brought, and where a 128 application is brought, it may be that the claimant thinks, well, I have to bring it within 7 days, even though I haven't got permission. So in this case, all the respondent needed to do was to point out to the tribunal, this is a nullity, and didn't need to engage further on its own case, but it chose to. But to conclude, to reach a determination that this was a nullity, the tribunal listed a hearing. Under my proposed route, a hearing would not be required, and no involvement from the respondent would be required either. The tribunal would direct the claimant that the matter was stayed, that the claimant had to provide an order as required by the civil proceedings order within a particular period of time. If the claimant did not do it, that the matter would be struck out.
But if the claimant doesn't, you're at the moment focusing on a situation of interim relief and emergency, but let's leave that to one side for the moment. If the claimant hasn't obtained the leave that he or she knew was required, and merely goes to the tribunal and presents his or her claim, why would they raise the question of leave subsequently? How would the tribunal become seized of the point and impose the stay that you're suggesting would be dealt with almost automatically, if they could have gone and got the leave in the first place? I'm just not following the logic of it. It seems to me that even in that situation, you're going to get into a situation of the respondent having to respond and engage, and until somebody else is alert enough to notice, the proceedings will trickle on.
That is the situation whether the the status of the claim is a nullity, or whether the status of the claim is a claim that can be stayed or struck out. Until the tribunal is made aware that there is this CPO, the proceedings will trickle on. So the issue, I say, is what is the just manner in which to deal with that set of circumstances?
If the course goes as you suggest, so the claim is stayed and then struck out if the claimant has failed to obtain leave from the High Court, can the claimant subsequently seek relief from sanction?
There would have been no substantive determination of the issues within the claim. The claimant could, probably out of time, present another claim and seek to argue that time should be extended.
Could the claimant seek, say the claimant failed to obtain leave from the High Court within the time specified, so the claim was struck out after the expiry of the stay, would the claimant then be entitled, if he then got leave, to seek to have the strikeout set aside and the claim reinstated?
He could make an application to the Employment Tribunal seeking a reconsideration of the decision to strike out on the basis that he now has retrospective permission and it's in the interest of justice for this claim to be reignited and progressed. And he may or not succeed.
And is that a claim that would be on notice? An application that would be on notice?
The application for reconsideration would be on notice. But at that stage, the High Court would have
given leave.
Yes, would have reached a conclusion that this was a claim that was not vexatious and was meritorious.
Suppose you have what I call a very vexatious litigant. This is in the abstract because we have to test this by reference to all vexatious litigants. This isn't aimed at your client. But suppose that every day he puts in an application to the Employment Tribunal and they write back to him each time saying, again, have to make an order that you must seek leave, in default of which it'll be struck out, and they give a timetable. And he just ignores that. He doesn't go and seek leave for any of them. He just keeps sending day after day after day claims to the Employment Tribunal. Isn't that just the sort of mischief at which a CPO is aimed, and which means that the court should not have to do anything, should not have to treat them as effective proceedings. A respondent should not have to respond to them to get them struck out. They can just be treated as a nullity and ignored.
Well, in that situation, the respondent wouldn't have to be engaged. The tribunal alert to this pattern, to this status, right, would write to the claimant to point out that this matter was stayed and would be struck out if permission was not sought. And after whatever period of time, it would yet again.
You say right to. I think this is a judicial function, isn't it?
Yes.
So it is going to involve not just an administrative letter. It's going to involve some time and expense and an application by a judicial officer.
Yes.
To whether it should be struck out.
So I accept a relatively low level, but nevertheless some involvement of the judicial officer.
Well, isn't that just the sort of mischief which it's the purpose of a CPO to avoid, having to take up valuable court resources?
I've got two responses to that. The first is, yes, that is a mischief which the court would want to avoid. The real mischief to which an order under Section 42 is directed is vexatious or unmeritorious claims being started and being assessed by the court as any other claim would be assessed, to the point at which a hearing for strikeout is.
Well, it's not just the substance of the claim, is it? I mean, we know, again, this isn't directed at your client, but we all have had experience of vexatious litigants who employ every possible procedural device. Suppose that when the first rejection comes, the litigant says, well, that officer should have recused themselves, they're biased. Does the court have to deal with that?
The court probably has to deal in some way with all correspondence which it receives.
Well, it has to if there's an application that the order that's been made, the strikeout order should be set aside because of the bias of the judicial officer, that the court's got to engage in that. Got to have an Article 6 compliant fair hearing on the matter.
I think the tribunal would be able to say you have no permission to bring that application. But my lord, yes, we can identify these situations where some judicial involvement would be required. But I say that judicial involvement is required even where the approach is taken that such claims are a nullity. The claim will progress because it meets, in all other respects, the requirements of the tribunal results.
Well, if it is a nullity, everybody can ignore it. No one has to worry about it. It's a matter of practicality. You may have someone in the administrative staff who says we're going to ignore it, and it may be that there'll be a repeat letter if it keeps happening. But in my example of someone who's doing it every day, staff won't need to send a letter every day. They'll simply say we don't need to engage in this correspondence anymore.
I would say that
all these claims are a nullity. Full stop.
Well, it may be that the court, after receiving several of these, could make that response, but that would be
not
a
on your
response.
case. Not on your case. In your case, there has to be a judicial officer involved in each case, making an order, which gives an opportunity for applying for permission, in default of which, then a strikeout.
But in your lordship's situation, early within that process, the judicial officer would have been involved in informing the claimant that this claim was a nullity and the next one, and that all future claims would be treated as a nullity. So there's...
Sorry. Yes. If it is a nullity, then that's the answer. Then
yes.
The court essentially can make sure it's no longer bothered. But if each such claim is not a nullity, it has to be engaged with judicially every time. Doesn't it?
I would say that the claim has to be engaged with judicially every time under both interpretations. If the claim is a nullity, I say the court, a judicial officer, does need to inform the claimant that the claim cannot be progressed because it is a nullity.
Why is that a judicial function?
Supposing the court does say nothing about this.
No, I wasn't positing nothing. I think I was positing first time it comes from a member of the administrative staff, and if it happens more than once, there may be one or two follow-up letters, but then the administrative staff can simply say, we've told you it's a nullity. It doesn't engage in judicial determination at all. That was what I was positing.
I think there are two solutions to this potential problem. One is contempt of court proceedings, because clearly what your lordship describes would be a gross, repeated breach of the civil proceedings order, and one which the court and other authorities may well be interested to take further.
So that involves the respondent having to commence committal proceedings, does it?
Or in some way the tribunal, perhaps the Attorney General. I haven't looked at exactly how this will be done, but there must be a route by which contempt proceedings could be brought in this situation. It may be, my lord, that there is a lacuna in the tribunal procedure rules, it may be that the rules do not address this situation, but they ought to. It may be that some provision should be made where, in respect of a particular claim or application, the court is sure that there is an order, it covers this individual, and that this is an application that falls within those restrictions. The tribunal rules could provide.
But they don't.
But they
So
don't.
in the absence of that, you say the remedy would be contempt, do you? What other remedy would there be? Or would the tribunal staff just have to keep on responding day after day? I know this is a hypothetical example, but we're using it to test your argument. And I say it's hypothetical. It's not hypothetical. It doesn't apply to your client, but it, as my lord says, there are litigants who do behave in this way in all, across jurisdictions, family, employment, everywhere.
Well, in that situation, I would say more is required than what the court, more protection is required than the protection currently provided by an order under Section 42. I say that Section 42 and the orders under it should not be interpreted to protect the court in those extreme circumstances when the effect on individuals who have meritorious claims could be so detrimental.
But isn't the remedy for someone in your client's position pretty straightforward? He just has to apply to the High Court.
But my question would be, since he has a meritorious claim, why should he not get retrospective permission?
Why doesn't? What is it? What is the problem with getting leave in advance?
So, in relation to the extreme jurisdiction of Section 128, it may be very difficult.
Well, that may be difficult, but in the general run of things, we've got 6-year limitation periods, 3-month or 6-month limitation periods in the tribunal. There's no difficulty in getting leave, is there?
I think there would be little difficulty for 6 years.
Well,
none.
but
And
even
perhaps
for
the
3 and
6
6 months.
By 3 months, by the time a litigant in person has established what their claim is.
Well, he knows he's been dismissed, or that something has happened that he regards as unlawful discrimination on a protected ground.
Yes, it might well take time to generate the materials to persuade a judge that this was a meritorious claim.
What materials? He just needs to set out his claim. What are the materials that he has to generate?
I would argue that the 3-month time limit is there to accommodate the time that it might take an individual to construct their claim. So if 3 months is permitted for an ordinary individual to construct their claim, 3 months may well be required for an application to the High Court. My lady, in this
3 months
Then-
for an
then-
application to the High Court.
But we go back to my point. If the time that he's allowed, and litigants in person are not treated more favourably than anybody else, if the time allowed to prepare the merits of the claim is 3 months, then he only needs 3 months less 12 hours once he's prepared his claim to get in front of a High Court judge, overnight if necessary, and say, here's my claim, please can I have leave? I've got to have it by tomorrow because it's taken me all this time to get my act together, and the time limit will expire tomorrow.
That is something which lawyers would understand as possible. It may be difficult for litigants in person to recognise that potential and the ability to generate leave.
Well, he knows, the litigant that we're talking about knows he's got to get leave in advance. He's been told that. He knows that the order's been made against him.
Yes, so in this particular case, the claimant's position was that he had informed his solicitor, and he believed his solicitor was going to seek permission. But the solicitor didn't, and therefore the claim was put in without having obtained permission. Now, when he raised the these arguments when he presented that evidence on his second claim. The tribunal, I accept the tribunal did conclude that that wasn't a good enough excuse to justify it extending time. But those were the arguments and the circumstances that the claimant raised.
But sorry, an individual who is the subject of a civil proceedings order will always know that he or she is subject to that order. It can't be made without them knowing.
Yes.
So they will always know when they have a cause of action that they wish to access, to make a claim in relation to, and to access justice, that there is a hurdle that needs to be surmounted before they can do that.
Yes.
And they will always know that that might take a little bit of time, not necessarily a long time, and that they'll need to cater for that in the steps that they take.
Yes. But in this case, we say, aware of that, the claimant did inform his solicitors of the need, and it was their mistake that this wasn't done. But also, yes, the litigant will be aware of the order. There may be some uncertainty as to whether it covers employment tribunal proceedings.
I thought that was it was accepted that
Yes.
court meant court or tribunal.
It is accepted,
Right.
but that was only determined in a decision, I think it was about 10 years ago. I can't remember when the decision was. But until then, there may well have been some uncertainty.
For the last 10 years, litigants who are faced with CPOs or made against them know that they cover court and tribunal proceedings.
Yes. So, my lady, my lords, we've been addressing the situation of a claim brought in breach of an order. Orders under Section 42 also cover applications made in existing proceedings. So,
That is existing before the CPO was made, not existing.
my understanding is that if an application needed to be made in a proceeding for which permission had been obtained, extra permission, further permission would be required for that extra application. So if this claimant had got his claim in time with the permission, but later in the proceedings he wanted to make an application in these properly instituted employment tribunal proceedings, on the terms of the order, he would have to seek High Court permission.
Really? That would be. I think that's quite a surprising interpretation of.
Should we look at Section 42?
Section 42.
See if you're right about that. Where is that? Section 42 is tab 3. I think.
Is it? Yeah. So you're looking at 1A(c), are you? No application other than one for leave under the section should be made by him in any civil proceedings instituted in any court by any person without the leave of the High Court.
Yes.
I have to say, it would be a pretty odd construction of that to say that it meant that in civil proceedings which he has had leave to institute under A, he has to seek leave separately to make any application in those proceedings.
Application to extend time for something. Or
Surely what it's aimed at is proceedings which aren't instituted by him, but which involve him making an application.
There is an observation in one of the authorities that supports my interpretation. If I could just, I apologise if I could just find it. Yes, so behind tab 22,
Johnson and Vaux.
yes. So on page 1507 of that authority, part of the judgment of Lord Justice Robert Walker, from D, between D and F, he says it's no doubt arguable that if Moses J. did address his mind to this point, he can hardly have intended that every single interlocutory application made by Mr. Johnson in the county court proceedings, for instance, for permission to amend his pleadings, should have to be solemnly sanctioned in advance by a High Court judge. But wherever the line is to be drawn between routine and extraordinary applications, the substantive appeal to the Court of Appeal must be on the far side of it. So I say that there may well be some applications within the permitted proceedings which are on the wrong side of the line. In those circumstances, the application might have been allowed, but later it's determined that it was on the wrong side of the line. The successful application would now be null and void, which would have an impact on those proceedings which had taken place between the grant of the application and the point at which it was identified.
Surely the judge, when giving leave to someone to institute proceedings, could anticipate ancillary or interlocutory applications in the course of those proceedings and give leave for those to be included. Wouldn't that be the sensible course? If your interpretation of 41(1)(a), 42(1)(a) is correct, then a judge giving leave to institute proceedings should include and makes interlocutory applications within the leave granted.
But there would still be a boundary.
That's what the claimant should ask for when seeking leave.
But there will still be a boundary which might be, the existence of the boundary might be deployed later in proceedings by a defendant who wanted to try to negate part of those proceedings. And because of that possibility, I say a more just response is such an application made outside of the terms of the permission the claimant had obtained would be vulnerable to being dismissed or struck out, but wouldn't, as the respondent argues, be null and void. So, my lords, my ladies, there are several circumstances which we can identify where a meritorious and non-vexatious claim would be identified as a nullity and void in circumstances which it is not necessary for the court to take that approach. Vexatious litigation can be managed successfully, perhaps not in the most extreme circumstances, but generally can be successfully managed by the approach which I advocate. If those extreme situations cannot be properly managed by my approach, it is because of a lacuna in the tribunal rules which could be addressed. So that extreme situation, I say, shouldn't cause hardship to claimants who do have meritorious claims, but who haven't quite complied with the procedures required of them.
The lacuna in the tribunal rules is the absence of a provision, is it, that it would be possible to deal administratively to bring to an end proceedings, even though they were not a nullity, they were valid proceedings. I rather doubt whether that would be Article 6 compliant or within the scope. The Rule 13 is rather carefully graduated to make sure that although there's an initial administrative function, a party whose claim is rejected has an ability to have that determined by a judicial officer, exercising a judicial function. But if the problems we were discussing are to be avoided by something that isn't in the rules, I think you're saying it is that although the proceedings are not a nullity, they are valid proceedings, they can be brought to an end by an administrative letter. And I'm just questioning whether that is a lacuna that could in fact be filled.
But in that situation, it is the decision of the administrator which stops proceedings being progressed any further. If that is not Article 6 compliant in that situation, I would argue it's also not Article 6 compliant for an administrator to write to say, we've received one of these letters each day of the last 3 weeks, and we're not going to respond.
Well, that's in a situation where it is a nullity.
No, if it's a nullity...
If it's a nullity, that's a different...
That's entirely different.
But I say that it needs a judge to determine whether it is a nullity. It isn't for the mere administrative.
Well, you wouldn't need to determine that it's a nullity. If on a proper construction of Section 42, the effect of commencing proceedings without leave is that they are a nullity, there's no need for a determination. They are a nullity. It can be dealt with administratively without any Article 6 difficulties. It's different if you're right and they're not a nullity and they are potentially viable proceedings that require a judicial decision. Then the problem that my lord is putting to you is it wouldn't be Article 6 compliant to have an administrative officer deal with them. Hope I haven't reflected that.
No, I understand. Perhaps if we look at civil restrictions orders, which are a comparable provision expressly provided for within Rule 311 of the CPR, but
Civil
also
restraint.
civil restraint, sorry, but also the consequences are expressly dealt with.
So just take a step back. What are you endeavouring to draw from the comparison, so we're alert to it?
I say that under the civil restraint provisions, the rules have identified what happens to a claim brought in breach of the order, and that it will be automatically struck out. I say that the Employment Tribunal rules could have provided for something like that, but they don't. It's not for the court to read into Section 42 or an order under Section 42. It's not for the courts to read in that draconian consequence.
What do you say the employment rules could have said? You say they could have provided for an automatic strikeout. In what context? In what circumstances precisely?
So the rules could provide for, at the paragraph 12.1 stage of examining whether the form is compliant or not vexatious, at that stage the Employment Tribunal should check the name of the claimant against the database of people subject to civil proceedings orders. If there is a match, the claimant should be written to by the tribunal to confirm that they are the same person and that they haven't got permission required.
And do you say that such a provision would have to be found in all rules of all tribunals of all courts to whom the CPO applied. So, civil procedure rules, family procedure rules, etc.
Some such provision, yes.
And in the absence of that, you say, what? I don't think such a provision does exist in any of the rules.
I'm not aware of it.
So what follows from that?
So that provision could be within the rules, or it could be provided by an amended section 42. That would be the way in which to ensure that across all jurisdictions this approach is taken. And it would be an approach, as we find in Rule 311 of the CPR. So, my Lord.
Speaking for myself, I don't find it very easy to answer the question, how is Section 42 to be interpreted? If the answer involves it could have been put in different terms in order to achieve the result that you say it does achieve.
Section 42 could include a provision which states expressly.
But it doesn't. And we've got to deal with Section 42 in its current form.
And I say that because it doesn't say that, and it could have said that, under the principle in Ex Granit, the court should take the view Parliament has not gone to the steps that it should have done if it was trying to remove rights in these situations. Because Parliament has not taken the steps that it could have done, this court should interpret these provisions to permit what I say is the more just, is the more claimant-friendly response. And of course, a response further down the line could be an amendment to Section 42, if that is what Parliament wants to achieve in the future.
Thank you.
Hello? Sorry.
I was just going to apologise. I've been blowing you off course a bit.
No, that's fine.
And,
I also say that, yes, tribunal rules in all the jurisdictions could provide for a similar response if tribunals take the view that this is something which they need to deal with.
And the absence of a procedural rule in many courts and tribunals, you say, merely supports your construction, that Section 42 was not intended to achieve the result that there would be an automatic strikeout or nullity.
It should not be read to have that effect, because if it was to have such an extreme effect, principle explains, clear words are required. It may well be that these consequences and the consequence of the litigant which my lord described, it may be that these have not been addressed by those who write the rules in sufficient detail. But that isn't a reason to interpret Section 42 and orders under it to be wider, more draconian than they need to. Shall I go back to the Employment Tribunal rule?
Well, as my lord says, we have rather blown you off course a bit. So why don't you go back to your submissions? We were in the rules, weren't we? Have we finished? You want to say more about the rules?
Which are behind tab 10.
Yeah. I think we got as far as 12 and 13. Do you want to say anything more about 13?
Yes, so under 13, a claimant whose claim has been rejected does have a right to reconsideration. So potentially rejection under 13 wouldn't solve the problem of this extreme vexatious litigation.
Yeah. It's a revivable claim, as it
Yeah.
were.
There is a step at which I say the tribunal can deal with a claim brought in breach. So paragraph rule 26, you see it page 52. Initial consideration. As soon as possible after the acceptance of the response, the employment judge shall consider all of the documents held by the tribunal in relation to the claim to confirm whether there are arguable complaints and defences within the jurisdiction of the tribunal, and for that purpose the judge may order the party to provide further information. So at this stage, if the tribunal has checked the database or the respondent has raised this issue, the matter can be raised.
This is after the acceptance of the response, isn't
Yes.
it? So here the claims got through, carried on, respondents responded.
But I thought your argument was it is within the jurisdiction of the tribunal in these circumstances, because the tribunal has to exercise its jurisdiction to apply one of the case management functions that you're about to take us to.
Yes, it is within the jurisdiction. However, because the claim... So I accept that the tribunal and the court have an interest in the fact that this claim has been brought in breach of the order, and that the courts and tribunals can take action as a result. Now, in a situation where the claimant hasn't sought the permission, hasn't obtained the permission of the High Court, I say the tribunal will have to dismiss the claim. It can't progress it on its merits to a decision. It has to dismiss by summary. It has to dismiss the claim. So there is no arguable claim in the circumstances where permission has not been obtained. So in this situation, the judge can follow this process. Under subparagraph 2, except in the case where notice is given under Rule 27 or 28, the judge conducting the initial consideration shall make a case management order. Now, in this matter, there was a case management order listing the matter for a hearing in January 2020. It was later converted to a hearing to consider the nullity point. But moving on to Rule 27. If the employment judge considers either that the tribunal has no jurisdiction to consider the claim or part of it, or that the claim or part of it has no reasonable prospect of success, the tribunal shall send a notice to the parties, setting out the judge's view and the reasons, and ordering that the claim or the part in question shall be dismissed on such date as is specified in the notice, unless before that date the claimant has presented written representations to the tribunal explaining why the claim or part should not be dismissed.
Which part of that do you say applies? It isn't a case where the tribunal has no jurisdiction to consider the claim. So you say this is a power that would then be capable of being exercised if, but only if, the employment judge has decided that the claim has no reasonable prospect of success.
Yes, and it would appear to have no reasonable prospects because the claim has not received the permission of the High Court. The claim can't succeed because the tribunal will strike it out.
Unless the High Court subsequently gives leave.
Yes.
So that the order you're contemplating, I think as you said, it's not simply a dismissal. It would be a stay for a fixed period of time to allow permission to be sought, leave to be sought from the High Court, in default of which, i.e. default of application or default of a favourable result, then the claim would be struck out.
Yes.
And paragraph 27 applies to the strikeout part of that order, because in those circumstances the judge would be saying it has no reasonable prospect of success.
Paragraph 27 is a parallel route to achieve a dismissal of the claim. So this is the route upon the first consideration, and under 27(1)(b, the tribunal could demand that the explanation is provision of an order granting consent within a particular period of time. There's Rule 37 permits the striking out of a claim. Under Rule 37(2), claim or response may not be struck out unless the party in question has been given a reasonable opportunity to make representations, either in writing or if requested by the party at a hearing. So this route, I accept, doesn't necessarily involve there being no hearing, because under the rules as they currently stand, where a judge tells a claimant that his claim is struck out because of failure to obtain an order, the claimant can request a hearing, at which that matter will be determined.
So 26 and 27 you say take place without a hearing, but 37 contemplates a hearing.
A hearing is possible under 27. Under 27(3), if representations are received within the specified time, they shall be considered by an employment judge who shall either permit the claim or part to proceed, or fix a hearing for the purpose of deciding whether it should be permitted to do so. Respondent may, but need not, attend and participate.
So the vexatious litigant is entitled to a hearing if he or she so chooses.
Under both 27 and 37, yes.
Thanks.
But of course, vexatious litigant here was the judge. Vexatious litigant was given a hearing by the tribunal in January 2020. But my lord, there's another route. So, going to the rules in the supplementary bundle of authorities.
Do you mean today's supplementary bundle?
Yes.
The one you
Yes.
we've got not the second volume, but the supplementary volume.
Sorry, supplementary volume of authorities.
Yes.
Yes.
The one today, Rule 29 you're going to, are you?
Yes.
Okay. Because we've got two bundles of authorities already.
Yeah, it's the new one.
You mean the new one?
I do. I hadn't realised there were two bundles of authorities.
Well,
The original bundle split into two.
it is.
I hadn't realised.
It's quite large. Okay, so tab 2 in the supplemental bundle, or you're going to the authority.
No, we are going to the rules, which I hope is in tab 2.
Yeah.
So, under Rule 1, titled Interpretation,
Yeah.
sidelined, we see sub-rule 3A, case management order being an order or decision of any kind in relation to the conduct of proceedings, not including the determination of any issue which would be the subject of a judgment. And then subparagraph B identifies the judgment. That is background to the next rule in this bundle, which is Rule 29, case management orders. The tribunal may at any stage of proceeding on its own initiative or an application make a case management order.
Right.
The next rule, Rule 31, disclosure of documents and information. The tribunal may order any person in Great Britain to disclose documents or information to a party by providing copies or otherwise, etc. So this rule would enable a judge to request an application for a permission and the order granting permission to bring these proceedings.
Sorry, just say that again. This 31 will permit what?
Will permit a judge to request of a claimant the application that they had made and or the order granting permission to bring these proceedings.
By the High Court?
Yes.
Doesn't say High Court, does it?
So the tribunal may order any person in Great Britain to disclose documents or information.
Oh, I see.
So that document...
And that's unqualified. It's my misreading, I'm sorry. Right?
Yes.
So that covers the position if the tribunal doesn't know
Yes.
whether leave's been granted.
Okay.
But speaking for myself, I'm interested just to pin down where you say the power is to make the kind of order that you say would be appropriate in a situation where there's an understandable reason for not having sought
Yes.
permission in time, and the right order would be stay it for a limited period of time to allow the litigant to go off and seek leave, coupled with a provision that if leave hasn't been granted within that time, then the claim shall stand struck out, which I could see would be the sort of order you would want to make in those circumstances.
Yes.
Now, where do we find the jurisdiction to make that stay application?
So
To make that stay order, sorry.
So that jurisdiction flows from Rule 29. The authority, the duty authority.
Well, I don't-
Duties about general stays.
General stays.
Ah.
You moved over 1.3 rather quickly, but 1.3b, Roman 2, at first sight anyway, suggests to me that the kind of order that we've just been describing would be a judgment, not a case management order, because it would be in relation to an issue which was capable of finally disposing of the claim, even if it did not necessarily do so.
So the order which I say the tribunal can produce is an order, yes, staying.
Yeah.
The power is Rule 29, supported by the interpretation in duty. So the tribunal stays the matter for a discrete period of time. Under Rule 31, the tribunal orders the individual to provide permission, an order granting permission for these proceedings. And then Rule 38 grants the tribunal the power to turn that order into an unless order. So Rule 38...
So when do they do that? When do they turn
It's all part of the same order, isn't it?
It's one single order, otherwise it's got to keep coming back to them.
Yes, so it is one order, which is an unless order. The tribunal stays the matter and orders that this permission...
Well, it's one order. So
Yes.
what Section 1 seems to envisage is you've got two types of order. It's either a case management order or it's a judgment. The order we're talking about is what?
I say that it's a case management order.
So just so I'm clear about this, the order which says what is a case management order?
The order requiring the claimant to provide the permission order, the High Court order.
It's the stay plus the requirement to go and get leave within a limited period, failing which the proceedings are struck out.
Yes,
That's the order.
That's the
that's
order.
the order.
Right.
Well, why doesn't that come within
3B2.
1.3b2?
Which is capable of finally disposing, even if it does not necessarily do so.
So, under 38, an order may specify that it is not complied with by the date specified. The claim or response or part of it shall be dismissed without further notice.
So isn't that a 3B2 order, decision?
As what's in the parenthesis rather confirms.
Mm.
3B refers to the judgment being a decision.
Mm-hmm.
Right.
That the unless order takes effect not because of any decision of the court, it takes effect because of the fact of non-compliance. But I would say that whether the effect of the unless order is that these matters are determined within the meaning of 3B isn't of any consequence.
Well, you say that, but Rule 29 applies to case management orders, not to judgments.
So the case management order is the request for the permission order.
Sorry, can you say that again? I didn't understand.
Yes,
It's not really a request for permission. It's
direction.
it's a direction
An order.
that unless and until leave is obtained from the High Court, the proceedings will be stayed, coupled with, one would have thought, that not being open-ended, but
Yes.
being time limited, with a provision that unless that's a favourable decision from the High Court has been obtained, the claim shall be struck out. That's the nature of the order we're talking about.
That's the nature of the order. I would say that the form, more specifically, in my mind, the order would be a stay for a limited period of time. Before the end of the stay, a copy of the High Court order must be provided to the tribunal.
Well, it must be obtained. All right, maybe you traditionally say it must be provided, but that's not the substance of it. That's in order to make sure everybody knows what the position is. But
Yes, but
it's obtaining it that matters.
so certainly I've in the past dealt with unless orders where an individual must provide to the respondent and the tribunal particular information or particular documents. So this is akin to that. And unless
Well,
the
it's
individual-
not. It's about him getting the leave. This is a case where he hasn't got leave. You're staying for the period in which he can go to the High Court, obtain the leave, and on that basis, the proceedings will continue. But if he doesn't obtain the leave or the leave is refused for whatever reason, and we're not just talking about your client here. I know
Yes.
your client has got leave. We're talking about the vexatious litigant who hasn't yet got leave. In the circumstance where the leave isn't obtained for whatever reason, the proceedings are automatically struck out. In other words, finally disposed of.
I'm saying that the tribunal doesn't need to go so far into assessing whether leave has been obtained or not. It being apparent to the tribunal on its face that leave hasn't been obtained or may not have been obtained, it doesn't need to examine whether leave has or hasn't been obtained in this circumstance. It can simply ask for provision of a copy of the High Court order.
So are you abandoning Rule 29 as a route for dealing with this?
No, I say that falls within 29. The order is, the matter is stayed for whatever period of time. Before the end of that period, the claimant must provide a copy of the High Court order. Unless the claimant has provided a copy of the High Court order, the matter is struck out.
Well, that finally disposes of the proceedings.
Yes. How does that help
That's
you?
the whole point.
That's still within 1B3. 1B.
Or are you
3B2, isn't it?
Are you saying there are two two decisions there? One is the stay, which is 3A, and the other is the strikeout if the terms of the stay are not complied with, which is 3B.
I say that the stay, the request for the document, and the unless order are all case management orders. But once the matter is finally disposed of by failure to comply with the unless order, that situation may well fall within 3B. But the stay and the request for information and the unless order itself are case management orders.
But 1.3 is only concerned with orders. So if you're right about that, there's nothing to fall within 1.3b at all. It's not the effect of not complying with the unless order. You've got to say that that's, and you do say, I think, the whole order comes within A as a case management order. And the fact that it has the same effect as an order which would fulfil 1b2 is neither here nor there. And that's what you're saying, I think.
I may not understand the issue completely. Under Rule 38, the second part of subparagraph 1, if a claim or responsive part of it is dismissed on this basis, the tribunal shall give written notice to the parties confirming what has occurred. I would say that the dismissal that correspondence with the individual informing of them, that is what falls within 3B. But what I don't understand is I don't understand whether the terms of 3B prevent this, what I say is a case management order being made under 29, 31 and 38.
Well, the point, that's my fault if I haven't made clear what my difficulty is. I think the point is we're contemplating one order, not two orders, by which I mean the order we're talking about in advance of going off to seek leave. It's either got to be a case management order or it's got to be a judgment. And if the effect of it is that it will finally dispose of the claim if no leave is obtained from the High Court, or on your example, no document showing that leave has been obtained from the High Court has been produced, then that's just what B2 is concerned with. Orders that are capable of finally disposing of the claim. And is your answer that because there will always have to be a further order in the eventuality that the unless provision has not been complied with?
Yes.
So that when it says in 38.1, an order may specify that if it's not complied with by the date specified, the claim or response or part of it shall be dismissed without further order. It doesn't mean that. It means there does actually have to be a further order dismissing the claim.
Yes, the dismissal is itself the order dismissing the claim. Obviously, unless orders are made regularly by tribunals, and there is no jurisdictional difficulty with them being made, the unless order attaches to what must properly be described as a case management order, the stay and the request for information. Whether by attaching the unless order to that, this turns this into a judgment, I'd say it doesn't, or whether a judgment is generated by a failure to comply with the unless order because the matter is dismissed. I say that doesn't have any significance to the issues that we're determining.
Can I go back to your assertion that the dismissal is itself a further order? That's, I think, what you said a moment ago. Is that consistent with how 38.2 is worded? A party whose claim or response has been dismissed in whole or in part as a result of such an order. Such an order must refer to the order in 38.1. An order must specify. The original order, an order may specify, etc. It doesn't accommodate the possibility of a further order dismissing. The dismissal is as a result of the order.
And picking up on my Lord's point, in my experience, that is how the order was framed, if it was an order in which a final opportunity was being given. So unless within 14 days you provide X, your claim shall stand dismissed without further order.
Yes.
But you're perhaps saying that would be a rather unfortunate interpretation of the rules, because in any circumstances in which the tribunal was minded to make an unless order, it might very well want nothing to happen in the meantime, to put the other party to expense. And if that has to be expressed as part of the same order and as a stay, then if the point I make is right, it's all one order, and there wouldn't be power to attach the stay element under Rule 29, which would be an unfortunate result.
If we consider the situation in the ordinary course of proceedings, it must be possible for the tribunal to order a stay pending party complying with a significant aspect of
Yes,
case
you
management.
you must provide your disclosure
Yes.
by such and such a date, and in the meantime, the opposing party need do nothing further in relation
Yes.
to the case, and if you fail to do so, then your claim will be struck out,
Yes,
which is in substance a stay coupled with an unless order.
yes. And I say that that sort of order could be applied here.
That's the sort of order which ought to be available to the tribunal in many different circumstances, and it would be unfortunate to interpret that as not available
Yes.
through the sort of route that I've been positing.
I do wonder whether that sort of order escapes 3B, because 3B says a judgment being a decision made at any stage of the proceedings which finally determines. So of course a decision to make...
Capable of finally disposing of the claim.
And the brackets, the example in brackets illustrates what is meant by that.
Sorry, I read 3B as a judgment being a decision made at any stage of the proceedings, then put in brackets, which finally determines, rather than which is capable of finally.
Well, the capable comes in Roman 2. Finally determines an issue which is capable of finally disposing. So the issue is, has he or she got leave? If not, the proceedings are automatically struck out. Finally disposed of the proceedings.
So we escape this in this situation because the stay and the request for information in unless order are not resolved by whether the claimant does or doesn't have leave. It's resolved by whether he provides a copy of the High Court order. So he may have leave, but he may fail to provide a copy of the order, and he would then be struck out. Of course, he can't comply with the order if he hasn't got leave. But this stay and this request for a document is not a test of whether leave has been obtained, whether he has complied with Section 42 order.
Now I'm looking at the time. It's 12:10, so you've going to an hour and 40 minutes. We've been interrupting you quite a lot. As you can see, we're interested in your arguments. I'm wondering how you're doing. Do you need to extend your time? We haven't, for example, got to the grounds of appeal.
Yes. I wanted to deal with the grounds of appeal having
Laid the ground.
laid the ground, because I say the groundwork.
Yes, I don't imagine you're going to be very long on the grounds of appeal once
The
we've got
grounds
through all this.
flow
Okay.
from.
But we haven't looked at many authorities
Yes.
yet. We haven't looked at Seal or Edwards. And you helpfully charted out where you were going. So,
I will endeavour to keep to half an hour.
thank you.
No.
I'll endeavour not to interrupt you so much.
It's not my lord.
If we could go to the provisions dealing with civil restraint orders.
Okay, yes, you were taking us there
Yes.
by way of analogy, and I pushed you off course there. I'm sorry. So,
So they are behind tab 11.
yeah.
And you find Rule 311, I believe, at page 111.
Is this the white book I've got here, effectively? Yes, it is.
Yes, it is.
311. Yeah.
So I just need to wait for my just to catch up. So, Rule 311 is at page 111. Civil proceedings order and an all proceedings order under
Having
section.
said I'd try and be quiet, I'm immediately going to breach my own
It always,
injunction.
it always
But
happens.
this is intended to be an intervention that's helpful to you. Essentially, as I understand your point, it is CROs are analogous to a CPO. The rules provide that in the event that they haven't been complied with, they should be automatically struck out.
Yes.
But Mr. Justice Arnold, as he then was, has held that the effect of that is it's subject to relief from sanctions, i.e. not a nullity, and so Section 42 should be interpreted in the same way for civil procedure orders.
Yes.
Is it any more complicated than that?
It's no more complicated than that, and I say that that is an appropriate conclusion because it protects the court quite sufficiently, protects respondents quite sufficiently, but does support the very important right of access to the courts. Of course, an individual seeking relief from sanctions would need to have the permission of the High Court to bring that application.
Do you want to say anything more about the analogy? Because that's which just answers under the CROs. Do you want to say anything more as to why that should apply under CPOs?
So the significant differences between CROs and CPOs are CPOs can be ordered where an individual has repeatedly brought vexatious claims. CROs are brought where an individual has brought a number of unmeritorious claims, so the vexatious requirement isn't there under CROs.
Yes.
And CROs are, by definition, time limited in a way in which CPOs may not be.
Well, there's a structure.
Yes, and CROs may apply to a narrower collection of courts than a CPO. But the purpose behind it is very similar. It is to protect courts and respondents from these unmeritorious claims and repeated unmeritorious claims.
And the other difference is CROs are made under the court's inherent jurisdiction, whereas CPOs are made under a statutory provision in primary legislation.
The other way around, yes, CROs are made under a statutory provision. Sorry.
No,
CPOs are statutory,
Section
CROs
42.
are inherent jurisdiction.
Yes, there is an inherent power
Yes,
to
the
make
CROs.
CROs.
Yes, that's what I said.
Yes, but it is also under statutory authority from the Rule 311. But there's a residual.
The rule, you mean?
Under delegated statutory.
Yeah, you're saying
Because the rules are statutory.
Yeah,
Yes, I see.
sorry.
secondary legislation. Yeah. Do you want to make any other points arising out of the comparison with CROs?
I say that because the court takes that approach here, there seems to be no reason why that approach could not be taken in the CPO jurisdiction. It appears to be a sufficient route to stop unmeritorious claims there. There's no adequate reason to take the view a similar route would not stop unmeritorious claims under CPO jurisdictions. So from paragraph 32 to 36 of my skeleton argument, I identify various authorities where I say in practice a different approach has been taken to that.
Sorry, which paragraphs again?
So my skeleton argument
36.
32 to 36.
Yeah. Thank you.
And in each of these authorities, a claim or application has been made either before or in parallel with an application for permission under section 42. And in all of these situations, the court did not treat the original claim as a nullity, but did or considered giving permission for that part of the application, which was a Section 42 application. So the first authority, Ewing and Security Services, which is behind tab 27. I imagine that may be in the second bundle of authorities.
No, it's in the first.
May I ask what is the point of
30. 30 is the
30 is
cut-off.
the last one.
Yeah. Thank you. 27. Do you want us to look at this?
yes? Thank you. So at paragraph 1, within the judgment of Mr. Douglas Brown, we see that Mr. Ewing wanted to make an application to the Investigatory Powers Tribunal under section 65(2)(a) and another of the Investigatory Powers regulations. At the end of that paragraph, the judge says he has already commenced that application and seeks leave retrospectively. Paragraph 3, two principal questions arise. Is the Investigatory Powers Tribunal a court within the meaning of section 42? And secondly, whether I am satisfied that there are reasonable grounds of the proceedings. Now, the final paragraph of the judgment...
So was it argued that they were a nullity? Or was his jurisdiction just assumed?
I don't believe it was argued.
There's abuse of process was raised.
Well, that's about
But
section
set-
42.
Yeah.
So this doesn't... Nobody addressed their minds to whether there was a procedural or a merely procedural or a jurisdictional bar.
Yes, but what it does show is that there isn't a universal and unvarying practice whereby
Right.
applications are treated as a nullity.
Right.
It was assumed that they were not a nullity.
Yes.
That's what it establishes.
Yes. But I also say that the nature of a breach of an order under section 42 is one that engages the interest of the defendant, and the defendant can point out that there's this breach, but also it engages the interests of the court. So if there is a practice of treating such applications as nullities, it's in the court's interest. It would be the court's practice, but that doesn't seem to be the case here. The next authority is another Ewing decision behind tab 30. And paragraphs 28 and 29.
This is Lord Justice Carmen.
Yes.
And this is in relation to costs.
Yes.
Yeah.
And as to whether the individual who had brought a claim which didn't have permission was sufficiently a party for cost to be awarded.
Yeah.
In paragraph 29 is where Lord Justice Carnworth sees much force in the approach you contend is right.
Yes, but prefers not to express a view.
Yes.
The next authority is behind tab 18. It's the Tottenham Magistrates Court.
This is the one that you produced in your final skeleton, isn't it?
Yes.
I'm sorry, I missed the reference.
Tab 18, 1A.
Tottenham Magistrates. Roger Gleaves.
And the relevant passages are on page 239. That's the bundle page 239. Page 5 of this judgment. So what I say the judge has done here, he has addressed the issue of whether such a claim is a nullity or could be struck out. But he hasn't coherently treated the errant claim as a nullity. He hasn't distinguished between the concepts of treating the claim as a nullity or striking it out, or the claim being treated as a nullity because it's been struck out.
Isn't, I mean, I may be wrong, but isn't what Lord Justice Evans is saying in the last paragraph endorsing the nullity interpretation?
He says...
He put, in the first paragraph you've marked,
Yes, first
he has two options.
Yes.
And in the last paragraph, he prefers the second option, even though he doesn't actually use the word nullity in that paragraph.
Well, I think there's only one option within the first paragraph. He says, on the other hand, it may be that the appropriate course...
Well, the first option is to stay.
The second,
Yes.
to strike out, is in effect a nullity.
So within the second option, I say he is not distinguishing between striking out or nullity. He says, on the other hand, it may be that the appropriate course, and the only appropriate course, is to strike out that application as being in effect a nullity.
But it doesn't end there, comma, a proceeding which should not have been commenced and should not now be allowed to stand.
Yes.
Now, although he doesn't use the word nullity in the final paragraph, he does effectively repeat that phrase, doesn't he? When he says, quite appropriate for this court to recognise these proceedings which seem to be brought contrary to the statute and contrary to the court's order. Not quite that phrase, but isn't that in effect what he's saying?
Well, he continues. He says, for that reason, it seems to me that the consequence of the decision which I have already arrived at, leave was required. The consequence must be, in my judgment, that the application itself should be struck out. So I say that he hasn't treated this as a nullity. He's treated this as a claim which should not be entertained. Therefore, he has struck it out, and that makes this now a nullity. I say he's not taking the approach that it is a nullity as a matter of law. If it was a nullity, there would be no need to strike it out, no power to strike it out.
So in other words, although he identified two options in the first paragraph you've marked, he was in fact adopting a third option.
Yes, within the second part of the first paragraph, there are two options. So there are three. There's stay, strike out, or treat it as a nullity. What he has done is he has struck it out. I would argue that the concept of treating claims as a nullity is itself a fiction. What probably takes place is that in circumstances such as this, the court does strike out the claim. As a result, the claim is treated as a nullity. But loose language, loose conceptualization have generated the idea of a fiction that these claims are always a nullity. I argue that in fact these are claims which all require a judicial decision, and the judicial decision tends to be to strike it out.
So, in effect, as being in effect a nullity, those words are otios.
Yes. It's either nullity, and there's no need to do anything further, or it is struck out, at which point it becomes a nullity.
Right.
So I say that the whole concept that this tribunal claim should be treated as a nullity is a misunderstanding of what takes place in practice.
Right.
Excuse me.
The respondents rely on two authorities, Guilfoyle and Velipillai, and I say this fits with my analysis on this point. The first, Guilfoyle, is behind tab 16.
Right.
And page 318 of that judgment. Sorry, I've misreferred the court. This is a different point. Could I take the court to the Velipillai decision, which is tab 39?
Yes. So, is this Mr. Justice Moscow?
Yes.
We're going to go back to Guilfoyle, or not?
No.
Okay. Velipillai.
Yes. So the paragraph I wish to refer the court to is paragraph 28, bundle page 535. So in the last two sentences, the judge says they are to be treated as nullities having been made in breach of the permission required. However, I will go on to consider whether additionally they should be struck out as being abusive. Well, there's no scope to strike out the claim if it is a nullity. I say there's confusion here as to what the concept of a nullity actually is. And what the judge has done here, by treating it as a nullity, he is striking out the claim. And then he is striking it out again on a broader basis.
Does he mean additionally or alternatively? You say he doesn't say that, so that's not what he meant.
Yes.
So what's this? What do you say is the status of? What does that do to this the authority of this decision? Because on the face of it, he says the penultimate sentence of 28 would be against you, wouldn't it?
It would, but I say in the circumstances of the other authorities where a different approach has been taken, where these matters are not being treated as nullities. And there is scope here to take the view that the judge is not clear as to the difference between a claim being a nullity, a claim being subject to automatic strikeout.
And therefore capable, but on the other hand, being capable of being struck out for other reasons.
Yes.
Okay.
So there's a lack of clarity.
Okay. Lack of clarity. Right.
Such that this authority, I say, doesn't support the suggestion that there is a practice or a legal principle where such claims are automatically nullities. And there's a key difference between a claim being a nullity, a claim automatically being a nullity, and a claim being automatically struck out. And it's a point that flows from the CRO ability to
Strike out automatically. The automatic strike out
and then
and
release
the
the
other.
instruction.
Right.
Because if this claim here is a nullity, there's no route, there's no relief from sanctions. If it's struck out, there is. And I say that's key. That difference is key in Section 42 CPO cases. So if I could move on to the seal, finally, if I could move on to the seal decision.
Right.
We see seal at tab 31, so early in the second.
That was the first one, that's right. Okay.
So first, if I could take the court to the end of paragraph 7 within Lord Bingham's speech. We find this at the top of page 444 of the authorities bundle. He posits the question which he answers within the rest of his speech. He says, the important question is whether, in requiring a particular condition to be satisfied before proceedings are brought, Parliament intended to confer a substantial protection on the putative defendant. And this is a key point. He then says, such as to invalidate proceedings brought without meeting the condition, or to impose a procedural requirement giving rights to the defendant if the claimant should fail to comply with the requirement. Here, what Lord Bingham has not identified is the possibility for a third status. He's identified a status where proceedings are automatically invalidated. He's identified a status of a claim where the defendant has rights to seek its dismissal. But there is a third route, which is certainly in CPOs, I say the court has an interest in terminating proceedings. And that falls between the two routes here identified by Lord Bingham. I say there's a route.
Well, isn't that just the second route?
It's a variation.
It's just a variation of the second route. You'd need it simply to be a procedural.
It is procedural, but it's more than procedural if the court has an interest and if the court will automatically dismiss a claim. I say it is closer to the first route.
Well, surely it's closer to the second route. It's a procedural requirement, not nullifying the proceedings.
But he says giving rights to the defendant if a claimant should fail to comply with the requirement.
Okay, well, let's see where you go with this.
So
the third way.
The third way. The conclusion as to section 42, we find that in the speech of Lord Brown.
Well, do you want to say anything more about what Lord Bingham says?
Not at this stage.
Okay.
So Lord Brown is the only judge who addresses directly the section 42 point. He does this in paragraph 74.
Yeah.
And in support of his conclusion as to the effect of section 139 of the Mental Health Act, he says just such a rule applies in respect of those adjudged vexatious litigants under section 42 of the Supreme Court Act 1981, and Parliament clearly intended to achieve the same result under the Mental Health Act legislation. I say there is scope for the same lack of clarity which I say exists in the authorities we looked at earlier. There is scope here for there being a lack of clarity as to what is the legal status of such a claim brought in breach of Section 42 order. If the understanding is that such claims are a nullity, but that understanding is because claims are always struck out and therefore treated as a nullity, this passage doesn't support, as is suggested, it doesn't support the conclusion that claims are automatically a nullity.
Well, 73. Can we go back to 73? What he's saying is, Parliament intended to make leave a precondition for any effective proceedings. That's the proposition, isn't it, that he is putting forward?
Yes.
And 74 is a commentary on that.
Yes.
Now, in that takes us back to paragraph 7 in Lord Bingham, doesn't it? Because in effect, he is saying, of the two conditions identified by Lord Bingham, I prefer the first.
Yes.
And we know that Lord Bingham agrees with him wholeheartedly, or whatever. He uses a phrase like that, doesn't he? I think it is wholeheartedly. Anyway.
He does wholeheartedly.
That's the phrase, isn't it? Wholly agree. Not wholeheartedly. Wholly agree. All right? So, yes?
But Lord Bingham has not identified this third route. I say the third route is consistent, is in fact consistent with what Lord Brown says in these 4 lines.
But you said it was closer to a nullity, not a procedural bar. It's a jurisdictional. So how does it help you?
Because of the distinction between a claim being a nullity, therefore the court can't engage with it, or a claim where a matter that can be automatically dismissed, which gives rise...
Can it only be automatically dismissed because it's not an effective claim without leave?
No, it's automatically dismissed because of the circumstances in which the claim is brought. As a matter of procedure, claims brought in these circumstances will be dismissed as a matter of routine.
It invalidates the proceedings, to use Lord Bingham's phrase, and the very inflexibility of the provision was an integral part of protection it affected, per Lord Brown at 73.
But what this analysis, what the question and what the response do not address is what actually happens in practice. Are such claims treated as nullity? Or are they dismissed? Are they struck out and then treated as a nullity? It doesn't address the scope for relief from sanctions. So I say that this analysis isn't the strong authority which is argued. In any event, it is obiter, and in any event we can see that the practice is not as universal as is suggested. Now, we can see from the Charities Act requirements for permission and the insolvency requirements for permission, they are both statutory bars on bringing claims unless permission is sought. They are comparable, closely comparable with the Mental Health Act provisions, and yet it's only the Mental Health Act provisions that do operate this bar, this extreme bar.
Well, they've got a different purpose, haven't they? The charities and the insolvency. Sorry, we're not interrupting.
No, they do have a very similar purpose, which is to stop claims being brought or entertained to protect the administrators or to protect the finances of the charity. So there is a very similar purpose. And I accept there's a very similar purpose behind orders under Section 42. The point I want to draw is within those three statutory bars, the Mental Health Act is an extreme. When you look at the Section 42 order, this is outside of that group of statutory bars. It's not a statutory bar. It's a bar created by an order, and the order has been made under authority given by statute. So if we're looking, I say we can look at a gradation from the extreme of the Mental Health Act through similar comparable provisions to something which actually has significant differences, which is an order under Section 42. And then if I could take the court to the speech of Lord Woolf. So this starts at paragraph 22. And the essence of his speech is that to prevent somebody from having access to the courts to resolve their rights, only the clearest language must be used. And there must be a good reason for that conclusion. And his analysis is that the language isn't clear enough here, and there is no sufficient need. I say that applies to our case. The language isn't clear enough. It's an order, not a statute, and there is no need to take this approach. If there is a need to take a more draconian approach, the right route to do is clearer express words in statute, order, procedural rules. And
we've read what Baroness Howe says.
yes, and she takes a similar approach. Now I say that these are strong dissenting judgments. You have a court where three of the judges agree with the stance of Lord Brown, but indirectly. They haven't each reasoned through. There seems to have been not the greatest argument, but the principle that Lord Woolf and Lady Hale is analysed in depth, and it is clearly applicable. The principle is applicable here, and I say that the application of that principle here is the outcome which I argue for. So I say that Edwards was wrongly decided because in this different circumstances, the obiter observations of Lord Brown don't bear the same weight. So, under a heading overriding objective within my skeleton argument, so from paragraphs 46 onwards,
Yes.
I address the sorts of factual circumstances which I say would generate an injustice under the respondent's position.
Well, we've read those.
Yes, and in fact, we have dealt with those to a significant degree in our discussions earlier.
Yes.
So I don't propose to go through those again. There is there's a series of orders in the Elliott case, which is right at the back of the second of the original authorities bundles. It's at tab 46.
Yes.
So we've been provided with these orders by one of the individuals involved, and what appears to have happened is that in a claim against the individual previously adjudged to be vexatious, he sought an urgent injunction without notice to the county court, in which he explained that he was subject to a CPO. The judge granted the injunction and listed a return date for 3 days later. On the respondent's analysis, that application would be a nullity on two bases. First, because it was submitted at the same time as the request for permission. It hadn't been submitted afterwards.
Yep.
But also because there wasn't permission.
Yep.
But at the return date, this issue was raised by the parties, and the county court judge he transferred the matter to himself, because he could then sit as a high court judge.
Yes.
Granted permission, transferred the matter back to himself as a county court judge, and dealt with the remainder of the injunction process. That's the effect.
Faint echo of what Sir Richard Scott did.
Yes. But I say it's the ability to do that sort of thing, to react in the moment to what justice seems to require, which is available under my analysis, but is prohibited under the respondent's analysis.
Right.
And I say that reserve power for the courts to provide justice between parties is a very important power, and ought to be available even in these circumstances to adjudged litigants, vexatious litigants. So that takes me to
Your grounds.
my grounds.
Right. Well, we've really covered the substantive issues, haven't we?
Yes. So if the court is with me as to the status of a claim brought without permission, or an application brought permission, then the grounds of appeal fall in favour of me.
Yeah.
They are a series of routes to challenge each of the decisions and approaches that's been made so far, but they either succeed or don't succeed.
It turns on your interpretation, doesn't it?
Yes. So, just in summary, ground one deals with what I say was the failure of the Employment Tribunal to recognise that this was a claim that had the approval of the High Court and it should have been progressed. Ground two alleges that the Tribunal and the Employment Tribunal should not have followed Edwards because it was wrong, for reasons I've explained.
Yeah.
And similarly in relation to ground three, but addressing seal and the errors I say that are in seal. 4 deals with the observation of Mrs. Justice Eadie, the President, that in fact inadvertently permission had not been obtained in advance of the EAT appeal. I say, if I'm correct, the later permission retrospectively grants that. Ground 5 deals with the proper interpretation of the Pitway order. I say, if you're with me, that
Yes.
should be interpreted as also, as I argue, and there's the point I made early on about the advantage, perhaps, of giving guidance as to how such applications for permission, applications for retrospective permissions, should be dealt with. So that's the 5 grounds. Unless there's anything else that I can assist you with.
Thank you very much, Mr. Wynne.
Thank you.
Now, Mr. Kemp, do you want to get started?
My lords, my lady, yes, I would like to make a start in the 10 minutes that we have before
Thank you.
lunch. And if I can begin with this, our central submission is that the terms of section 42 are clear. Permission must be obtained before a claim is presented. A failure to comply with that requirement invalidates the claim. It is a nullity. The High Court cannot give retrospective permission. That's the end of the matter. There's no lacuna here because section 42 provides the answer. It is a jurisdictional rule. Where there's a CPO, all courts and tribunals obtain their jurisdiction in respect of the proceedings from section 42 SCA without the requisite permission obtained before the institution of the proceedings. There are no proceedings, it's a nullity, and there's nothing on which any court rules can or orders can attach.
And surely the courts and tribunals obtain their jurisdiction from elsewhere. Section 42 might deprive them of jurisdiction, it's not a slight point I'm making, because you say there are the clear words of section 42. It's a condition for the institution of proceedings, but that doesn't tell us what the answer is as to what the status of those proceedings are if there's been a failure to comply with a condition, does it? Just the language.
We take that point. It's a jurisdictional rule, but it's a rule which has the effect of depriving jurisdiction that a court or tribunal would otherwise have.
Well, that's to assert that which you have to set out to prove.
If
What is it? What is it in the language that makes it a jurisdictional rule?
Well, we'll take the court to several features of construction of section 42 to support that position.
Right.
It's not just the language, though, it's also the purpose of the provision. And we adopt exactly the same approach as Lord Bingham at paragraph 7 of Seal to that issue. And I would like to develop those issues first, if I may, in due course. It will probably be after lunch, I'm afraid. But turning to the object and the purpose of a CPO, we say that is clear, twofold: to deter a vexatious litigant from issuing claims and to debar them from doing so until they obtain the necessary permission. And that provides substantial protection for putative defendants, courts and tribunals. It's permission that is an important and necessary safeguard against vexatious litigation. And we respectfully submit that my learned friend's case drives a coach and horses through that self-evident purpose, because permission no longer operates as a filter if it's given retrospectively. The putative respondents or defendants to a claim, the courts, the tribunals, judges and their administrative staff are required to respond or otherwise deal with the claim until such time as the CPO has been identified, it's become apparent. Here, it was for the respondent. The respondent had to take that onus and incur the work of having to put in a substantive response and take the point, and until such time as the court or tribunal decides to stay, strike out, dismiss, or not to grant relief. And we say that runs very contrary, wholly contrary to the very purpose of a CPO. We also submit that permission on the appellant's case no longer operates as a deterrent, because a vexatious litigant is free to institute proceedings first and obtain permission later. We submit that undermines the deterrent effect. A vexatious litigant is not debarred if they can issue a claim first and seek permission later. And so the structure of these submissions will be as follows. Firstly, I want to make, I think, 4 points of statutory interpretation of section 42 of the SCA. I then want to take the court to, I think, 4 cases which support the respondent's case in this appeal as to the object and the purpose of the CPO, including seal. I would like to then address my lady's point that she raised in correspondence around the ET's stay powers and unless order powers in a case like this. And then I'm going to address a few of the cases relied upon by the appellant. You have the benefit of our skeleton argument, if I might say, comprehensively goes through those cases, and we repeat and adopt many of the points therein, but I will highlight a couple of the cases that my learned friend has referred to in his oral submissions. And then I will make brief, I hope, summary submissions on the grounds of appeal. I think if it's a convenient moment, we could pause there, or if you're content, I can launch straight into...
Why don't you give us your first point on the statutory submission? So
the first point is an important one, and a fundamental one, which is
so
this.
let's get
If we go
the statute in front of us.
to page
Tab 3.
Page 9, tab 3.
Yes,
the
thank
authority
you.
funding.
Thank you. We're all substantially working on paper, yeah? Yes.
And it's it's section 42(1)(a), which is that a CPO, by definition, has been ordered where the High Court has held that someone has habitually and persistently and without any reasonable ground instituted vexatious proceedings, made vexatious applications, instituted vexatious prosecutions. So what we say as to that is that by definition, a CPO inevitably will be an order made in respect of someone for whom the ordinary powers of a court or tribunal have not been enough, or have not been considered to be enough by the High Court judge to control the vexatious proceedings. And we say that's a very important context when it comes to construing the provisions that follow and meeting the argument raised by my learned friend on his case, that you approach the matter from the other way round and you look at the tribunal rules of procedure rather than what we say is the right approach. You start from section 42, its words, its object and its purpose as informing the issue. So that's our first and fundamental point. And just before we part for lunch, I would say this: where the CPO sits in the orders that control vexatious litigation is right at the top of the hierarchy. It's where other orders have been considered to be insufficient to control the vexatious litigation, and then the Attorney General has to make the application, the High Court judge has to consider it, and the terms of the order are, we respectfully submit, intentionally draconian. So we would say that my learned friend's argument that really it's analogous to CRO misses the point. It's clearly not. This is a more draconian type of beast than a CRO. In any event, we do take issue, as you'll see from the skeleton argument, as to how the courts have approached the consequences of breach of a CRO, the Volupoli and Cooper tension, if I put it that way. But as a matter of principle, the CPO is one which is right at the top of the pyramid.
The hierarchy.
And the hierarchy of weapons in the armoury of the court to call a halt to vexatious litigation.
Thank you very much. We'll rise there and resume at 2 o'clock.
Right. Have a night with the chair.